Well, good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, March 9th, 2022. The time's 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janecka, as well as our General Counsel, Mary Smith, and I'm John Neerman. Today's meeting is a hybrid meeting, and that means that most of the participants, or many of them anyway, are joining us virtually, so please keep your microphones muted when you're not speaking. And for those who are making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the Commission on a particular topic, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to speak to, and we will do our best to accommodate that request. With that, I'd like to thank everyone for being present, and Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the proposed order concerning the Executive Director's denial of the application by Joseph Ferguson for a water system operator license. The parties have been notified that the applicant, the ED, and OPIC will each have 5 minutes of oral argument time and will present in that order. The applicant may reserve a portion of his time for rebuttal as he bears the burden of proof.
And Mr. Ferguson, are you with us today?
Yes, sir.
Well, you have 5 minutes. You can reserve any time for rebuttal, and I'll turn the floor over to you.
Yes, sir. Yes, I would like to, I was denied, and I just want to say that I've been with the Mud District here for 4 years, and I would like to move forward with my career. I understand that I made some mistakes in my past, and I was put on probation, and that's the reason for my denial. So my question is, once I successfully complete my probation, can I reapply and be granted a license to move forward with my career? And I would like to reserve the rest of my time for rebuttal.
Sure. And normally our practice up at the dais here is for the commissioners to take in information, hear arguments, and not to answer questions. But I'll make an exception, and I'll answer this one because I was going to do that later anyway.
Yes, sir.
This action, in my mind, colleagues, is not a bar to Mr. Ferguson receiving this license in the future. So with that, let's turn next to the Executive Director. Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Alicia Ramirez, and with me is Ms. Haya Zeman, PE, Deputy Director of the Occupational Licensing and Registration Division. We represent the Executive Director in this matter. The ED agrees with the Administrative Law Judge's proposal for decision and proposed order and recommends that the Commission adopt them without changes. We are available for any questions.
Thank you. I have none. Commissioner Lindley, any questions? Commissioner Janecka? No? All right. And let's hear next from OPIC.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Pranjal Mehta for the Office of Public Interest Counsel. OPIC agrees with the ALJ's recommendation that the Commission deny Mr. Ferguson's application for a new water system operator license. As discussed in OPIC's closing brief submitted to the ALJ, Mr. Ferguson's criminal history raises concerns relating to the duties and responsibilities of a water system operator. In addition to the third-degree felony for tampering with evidence resulting from the 2016 Matagorda County proceedings, the record also includes Mr. Ferguson's convictions in 2016 Dallas County proceedings for the Class A misdemeanors of evading arrest and having a false driver's license. These convictions directly relate to the duties and responsibilities of a water system operator and maybe even more germane to concerns about possible fraud. Therefore, OPIC agrees with the ALJ that Mr. Ferguson's criminal offenses directly relate to the occupation of water system operator, and that Mr. Ferguson did not satisfy his burden to prove his fitness for the license. Thank you, and I'm happy to answer any questions.
Thank you. I have none. Commissioner Lindley, any questions? Commissioner Janeka?
I wonder if it's appropriate to put the question that Mr. Ferguson asked us to ED and to OPIC. And I understand that that's forward-looking hypotheticals, but that's the only question in my mind.
Sure.
So, Ms. Mehta, I'd love to ask, and I'll return back to ED staff as well. The question Mr. Ferguson raised, does the simple fact if he reapplies and he remains under probation, is that fact dispositive of him being eligible for issuance of a license, or would policy and posture suggest a different response or position from OPIC?
OPIC agrees with the position that ALJ has taken in the PFD that Mr. Ferguson is in fact on probation currently, and it is undisputed fact on the record. At the same time, for this particular time, Mr. Ferguson's prior convictions in 2060 Dallas County proceedings are more related to the concerns about possible fraud related to the duties and responsibilities for this license.
Thank you. And Ms. Seaman or Mr. Ramirez, do either of y'all have any comments on that?
These denials are not a permanent denial or a bar. So clearly, when time has passed and the probationary requirements have been met, and at that point there is enough burden of proof or rehabilitative efforts, then the case will be considered like brand new. So there's no way of making a determination at this point, but there will be a fair consideration of the case once new evidence gets entered into the case.
Thank you, Ms. Seaman.
All right. Mr. Ferguson, we'd like to give you the opportunity to offer any additional thoughts or comments in your rebuttal. You have a little over 4 minutes remaining. Do you have anything else to add? And you might check your mute button because we can't hear you right now.
Yes, sir.
There we go.
What I would like to say is basically I have successfully completed 2 of my probations. I have 1 left, and it will be successfully completed in June 20th. So I guess from that point, I will reapply, and I guess we'll just go from there. Since they told me that the case would be brand new, I guess it's reconsidered once I show proof of rehabilitation. And that's all I really would like to say.
Okay, appreciate that. And Mr. Ferguson, I imagine that you haven't participated in a TCEQ hearing before or really been in a setting like this, and and I'm not sure if you must be a really good note taker if you can keep track of all this stuff, but if you're like me, you'll have to hear it a few times before all of it sinks in. So what I'm getting at is if any of the comments or arguments made today slip past you just in this presentation, we keep a video of this meeting archived. I think it's on YouTube, but you can certainly find it with a few Google searches. So if you want to go back and listen to it again to understand exactly what the arguments were and what we're making, the points we're making, you can use that as a resource. Colleagues, I came out where others did, and that is that Mr. Ferguson simply didn't meet his burden of proving that he was fit to have this license. So, on a different presentation of facts, it may look different, but I don't have a basis to depart from this proposal for decision. And again, I think we might look at this differently if Mr. Ferguson had submitted letters from the prosecutors or the correctional authorities in terms of his rehabilitation, or letters of character reference from his employer. That came up a few weeks ago. So really, he just needs to carry his burden on this. So that's my take. Commissioner Lindley?
I'm in agreement. I think we should move forward with adopting the ALJ's order. You know, I would say, as has come up today, that he may apply again in the future, and it doesn't guarantee that he's going to get a license, but he has every opportunity to reapply. And so I will commend him for looking to the future in that sense, and just trying to further his career. So that's all I'll say.
Commissioner Janeka?
I think I'm also in agreement, and I'll just circle back and express my appreciation for the answer and comment you provided, Chairman. I think I'm fairly aligned with where it sounds like you are on that issue in particular. I don't see the applicant's parole status as the high hurdle to overcome here. I think the absence in the record of any of those letters from law enforcement, sounds like there were some successfully completed probations where there may be some probationary officers who could provide testimony. And I'm not sure that I see any magic to, after the being entirely out of parole status versus in status, there's many factors that our agency is required to consider. I think that it may be very hard for us to reach the decision to issue an applicant a license, but there is a process where we refer these matters to SOA, and the administrative law judge considers all of those factors and sends a decision back to us. And I've seen matters in this space come back with other outcomes with some of these letters present in the record. It seems to me that that's the big factor. So, Mr. Ferguson, just to try to state it a little bit more in plain English, please do reapply, and please try to get some letters of recommendation that we specifically call for in our rules. I think that that seemed like a critical factor in this case.
Thank you for that. I think we're ready for a motion.
I can make a motion. I move that we adopt the administrative law judge's proposed order.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by Harris County Municipal Utility District number 495 for TPDES permit number WQ001 5222001. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Thank you for that. For the benefit of those who aren't familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a case. And then that assuming at least one requester has met those requirements, we consider which issues are appropriate to refer. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. And colleagues, in this case, we have Christopher Spicer and Denisha Spicer. Both have requested a hearing. All of the evidence and arguments indicates that they're entitled, that they're affected persons. The executive director and OPIC took that position. The applicant took no position on effectiveness, so I would grant their requests. It's also clear that among the numerous issues that the Spicers raise, some are relevant and material. And so I would refer the following issues: whether the draft permit is protective of the health of the requesters and their families, protective of livestock and wildlife, protective of water quality, including the uses in the receiving waters and the prevention of algal blooms, protective of groundwater, protective against nuisance odors, and whether the draft permit complies with the Commission's anti-degradation policy. So let me pause there. Commissioner Lindley,
I'm in
how does that
agreement.
strike you?
I'm in agreement on the parties and the issues.
Commissioner Janeka?
Likewise.
Okay, and I think since there's just two requesters in this case, that an ADR referral would be appropriate, and I think I'd also allow the full 180 days on this one.
I agree.
I agree as well, and I have a motion.
Great.
I move that we grant the hearing requests of Christopher and Denisha Spicer, deny all remaining hearing requests, refer the matter to the TCQ's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling efforts, and refer the applications to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of the health of the requesters and their families. B, whether the draft permit is protective of livestock and wildlife. C, whether the draft permit is protective of water quality, including the protection of existing uses of the receiving waters and prevention of algal blooms, in accordance with applicable regulations, including the Texas Surface Water Quality Standards. D, whether the draft permit is protective of groundwater, including nearby private wells. E, whether the draft permit adequately addresses nuisance odor in accordance with 30 TAC 30913, and F, whether the draft permit complies with TCQ's anti-degradation policy and procedures. And finally, that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, please call the next item.
Item number 3 is the consideration for approval to publish and solicit comment on 4 draft total maximum daily loads for indicator bacteria in tributaries of the Neches River below Lake Palestine. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Kerry Neiman with the Water Quality Planning Division in the Office of Water. And with me today is Nicole Hall with the Total Maximum Daily Load Program and Stephanie Scogan with the Environmental Law Division. Today, the Executive Director is respectfully requesting public comment of 4 total maximum daily loads for indicator bacteria in tributaries of the Neches River below Lake Palestine. The TMDLs cover 4 assessment units in 4 water bodies within Angelina County. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL document. The development of this document included an active public participation effort and balanced stakeholder group coordinated by TCQ and the Texas Water Resources Institute. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop the document to improve water quality in their communities. The Executive Director respectfully requests approval to publish total maximum daily loads for public comment. Permission is also requested to make non-substantive and clerical corrections before providing the documents for public notice. Thank you, and we're available to answer any questions you may have at this time.
Thank you, Mr. Neiman. I have none. Commissioner Lindley, any questions?
No questions, thanks.
Commissioner Janeka?
Just want to ask about the implementation plan. Is that also moving along with stakeholders providing input?
Yes, sir, it is. It's under development right now.
Excellent. Thanks.
Ms. Smith, is anyone signed in to speak?
No one is signed in on this item.
Okay, and what say the Office of Public Interest Counsel?
OPIC recommends approval for publication of the 4 total maximum daily loads for indicator bacteria presented by the ED so the Commission may receive and consider public comment.
Thank you. Colleagues, I think that's right. I think these proposed TMDLs are ready for public comment.
I would agree. And I can move that we approve the publication of and solicitation of public comment on 4 draft total maximum daily loads for indicated bacteria in tributaries of the Neches River below Lake Palestine as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next items.
That takes us to the enforcement docket, items 4 through 18. And the Executive Director's staff is here to present these items.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 4 through 18. The total assessed administrative penalties are $189,403, with $33,376 deferred, $9,590 applied towards supplemental environmental projects, and $146,437 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley.
No questions, thanks.
Commissioner Janeka.
Likewise, thanks.
And Ms. Smith, is anyone signed in to speak?
We have people signed in on item 6, but they're just there in case the commission has any questions, and they'll be noted for the record.
Great. Thank you. And Mr. McWhorter.
My office reviewed these items, and we recommend approval of the orders as presented by the ED.
Thank you. Colleagues, I agree with that. I think I'm ready to move forward with this docket.
I would agree.
Likewise, and I'll move that we adopt items 4 through 18 as recommended today by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 19 is the consideration of the publication and hearing on proposed amended sections of 30 Texas Administrative Code, Chapter 307, regarding the Texas Surface Water Quality Standards. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Lori Hamilton with the Water Quality Planning Division, and with me is Earl Lott with the Office of Water, Jill Secketts and Sarah Eagle with the Water Quality Planning Division, and Stephanie Scogan with the Environmental Law Division. The proposed rulemaking would provide a periodic public review and revision of the state's surface water quality standards as provided for in the Texas Water Code, Section 26.023, and required by the Federal Clean Water Act, Section 303C. The Texas Surface Water Quality Standards were last revised in February 2018. The proposed revisions to the standards include substantive changes and clarifications and incorporate new information and studies on the appropriate uses and criteria of individual water bodies. The revisions incorporate new scientific data on the effects of specific pollutants and address new provisions in EPA guidance. Other proposed revisions include a clarification to prohibit the discharge of visible pre-production plastic into surface water in the state. Regulated entities who will be required to comply with the proposed rule will develop and implement best management practices to prevent the discharge of pre-production plastic. Clarifications regarding the use of temporary standards are also provided. The proposed revisions also include changes in the basic numerical and narrative requirements of the standards that apply to all surface water in the state. The revisions and additions to site-specific uses and criteria in the appendices of Section 307.10 are tailored to individual water bodies and are based on studies and evaluations of each water body. Use attainability analysis have been conducted as needed to develop revisions to uses or associated numerical criteria. A hybrid in-person and virtual public hearing will be offered on this proposal in Austin on May 2nd, 2022. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 307 of the Texas Administrative Code, the Texas Surface Water Quality Standards. Staff also respectfully requests permission to make non-substantive revisions to comply with the Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you, Ms. Hamilton. I have none. Commissioner Lindley, any questions?
No questions.
Commissioner Janeka.
Likewise, thanks.
Ms. Smith, has anyone signed in to speak?
No one has signed in on this one.
And Mr. McWhorter, what do you think?
My office has reviewed this item, and we recommend approval for publication of and hearing on the proposed amendments to the Commission's Chapter 307 rules as presented by the Executive Director.
Yeah, thank you for that. I agree. I think we're ready to put this out for comment. There is a lot of interest, of course, in the prohibition on the discharge of visible pre-production plastics And setting aside the question or the debate about whether this is a substantive change or a mere clarification, practically speaking, it's already prompting many regulated entities to make operational changes and investments, or at least planning for that. And as always, our goal is compliance, and we want to work with the regulated community to see that their implementation of changes is prompt and orderly and effective. And so that's going to require a reasonable timeline for implementation. I think the key here is going to be good communication between TCEQ staff and the regulated entities as we roll that out. And we're just at the proposal stage now, but it's certainly not too early for that. So those are my thoughts. Commissioner Lindley?
You know, I was only going to make one not super substantial comment, but a comment that I noticed OCE is sitting very close to the table, and I think that's telling. I think that's important because I do think, you know, while OCE is always involved in rulemakings at the agency, I think it'll be very important moving forward, and especially in communications with the stakeholders for OCE to be at the table. And that's all I'll say.
Thank you for that. Commissioner Janeka.
I appreciate you raising that point, Chairman, and appreciate your comments. Commissioner Lindley, I certainly agree on the importance of OCE's role in this moving forward in the discussion with hearing from stakeholders. I'm very eager to watch comments come in and to hear from the stakeholders as this rulemaking proceeds. The point you raised specifically, Chairman, whether it's clarification or new requirements, my understanding is that was an issue that came up during the most recent legislative session, and our agency staff participated and were certainly given the impression that reflected a general consensus that the standard is none, and relief that maybe need to go from there. But I think that's a question that will be useful to see fleshed out in the context of this rulemaking. So happy to move forward. Thank you all.
Thank you, Commissioners. I think.
Oh, go ahead.
Go ahead.
I was going to say, I have a motion
Let's
if we heard
hear
from
it.
everyone.
Yeah, I think we're
Okay.
ready.
I would move that we approve the publication of and hearing on the proposed amendment sections of 30 Texas Administrative Code, Chapter 307, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 20 is our public comment session, and currently we don't have anyone signed in to speak, but we'll pause here for a moment, unmute the line, and just see if anybody wants to address the commission.
Hearing none.
We'll move on
I don't
to-
see anybody rushing for the podium or the mic, so
either,
I think we're good to move forward.
Agreed. Items 21 through 24 are for closed session, and the commission will not be meeting in closed session today.
And with that, the time is 9:58 a.m., and we are adjourned.